All right.
Okay, I'm going to go ahead and welcome everybody. I'm Candace Boothby, the President and CEO of the Noonan Coweta Chamber, and I'd like to welcome everybody to our Back to Business call this afternoon. These are 30-minute calls that we do about every week, every other week. We're focused on tools to help you on your road to recovery. A lot of great conversation going on out there right now with our 5 subcommittees, and a lot of questions, a lot of uncertainty. So we're hoping that we can shed some light on some of these issues this afternoon. We are so delighted today to have 2 experts in the area of HR law, and specifically the ability to drill down into COVID. It's not easy to find somebody who has this type of information and skill set, but we're very grateful to our friends at the Georgia Chamber for leading us in this direction. And I am going to butcher your name, Mel. So our dear friends Mel and Graham are with us this afternoon, and I'm going to let them, they're based out of Macon, and it's a very prestigious firm, Constangy Brooks Smith. Say it again.
I practiced. Contangy, Brooks, Smith, and Prophete.
Prophete, yes. So very highly recommended. In fact, recommended as the #1 firm in the state for this kind of information. So with that, I'm going to turn it over to Mel and Graham. And same format as we always use. I'm going to let Susan share that before we actually turn it over to Mel and Graham.
That's right. Thank you. And thank you again, Mel and Graham, for joining us today and for preempting the pronunciation of your esteemed organization. That being said, anybody who might have questions for Mr. Haas or Newsome, you can simply use the chat function to ask that question. And once we get toward the end of the presentation, time permitting, we'll go ahead and get those answered. You'll see a little bubble at the bottom of your screen. If you mouse over, it says chat. We'll type a little welcome message there so you know where to find it. And we encourage you to use that if there's something that comes up during the presentation that triggers a hot point for you as a local employer or proprietor. So with that said, I don't want to take too much of the time that we can use for this informative presentation. So I do turn it over to attorneys Haas and Newsome. Uh-oh. Graham, are you able to hear us?
Something may have happened when you gave him the co-host privileges to put the
It appears, yeah, it appears as if they've gotten disconnected. So I'm going to keep an eye. We were having a few issues at the onset with connectivity. So we're going to take a pause and wait for them to come back into the waiting room. But, you know, this is really kind of a good opportunity while we are waiting. If there is something that drew you to this particular presentation, a specific issue that you're having, or something that's a burning question that you have as we navigate the reopening and everything that carries with it, maybe take this time to go ahead and get that typed into the chat box so that we have them queued up and we can make the most of the time that we have with Graham and Mel.
Well,
this is a
odd.
new experience.
I've never had this happen. Well, let me see if I've got their phone number. Do you have their phone number?
Yeah, I believe I do.
You could tell they couldn't hear us because he just sat there looking at us.
Yeah. Oh.
Somebody has some pretty birds in the background. I'm not sure who that is.
I fear it may be me as I sit next to the
window. Is it you?
Since nobody's actively presenting, we'll just listen to the beautiful chorus for a moment. Here we go. Are you calling them or would you like me to?
I'm still looking for it. If you have it.
I've got it. I'm going to mute myself.
Okay. It's a good group. I really want to say hi to everybody. There we go. He's back. Does he know to unmute?
Mm-hmm.
We had a little blip.
There we go.
Here we are. Okay. Welcome back.
Okay. Go ahead.
There we go.
Instructions. There we go. We ready? Yeah.
Excellent.
Okay. Well, should we jump right in and get going? Yeah. Let's go.
Yeah, let's do that. And then when we recap, we'll go ahead and make sure that everybody that receives the recording of this call has access to your biographies and any other pertinent information.
Well, it's our pleasure to cover these issues with you today. As we were talking a little before, our firm is a labor and employment specialty firm with over 30 offices around the country, several hundred lawyers, and since 1946, we practiced labor and employment law out of Atlanta and the rest of the country. And of course, just in the last several months, we've had unprecedented issues arise with the coronavirus and created special issues. So we've devoted a number of lawyers in our firm. Graham Newsome here with me is one of them who spent virtually most of their time becoming familiar and responding to client questions about the virus and the impact it has on the workforce and the various regulations and laws that have been passed to address that. And then, of course, most importantly, some good common sense approach to dealing with issues. So with that, I'll let Graham jump in and get us started.
Okay. Good afternoon, everybody. Sorry about that technical glitch earlier. My name is Graham Newsome. I'm an attorney here in the Macon office. You just heard from Mel Hayes. He's the managing partner here in Macon. Like you said, we're a labor and employment specialty firm. We have offices all over the country. So if your business isn't just limited to here in Georgia, we can probably, put you in touch with someone who can help you with any issue that you have, depending on the state you're in. So I had prepared some slides just to kind of lay out what we're going to talk about today. There's some practical issues that we were going to go over, but due to our little technical glitch and being the fact we only have 30 minutes, we're going to go right to the juicy stuff, the stuff that you want to hear about. So I'll talk about some things, then Mel is going to talk in just a few minutes about some issues as far as employees who may protest coming back to work due to safety or some other situations. So as I mentioned, there are some slides here at the beginning that I'm going to skip through. Just be sure to review those after the fact. They're practical measures that you need to be instituting if you haven't already. And these are things that the CDC and other state agencies have suggested. Again, you probably are already instituting these, but just be sure, if you haven't taken a look, just to get another idea of what, our clients are doing. That way you have some guidance to go off of. So I'm going to skip these and I'm going to go to liability waivers, okay? And it's about the 7th or 8th slide in the presentation. So I know that was one of the topics that you have a lot of questions about. And so liability waivers, if you've never seen one, this is kind of an example of a liability waiver. So you can see these, if you go on a cruise, typically they're included on the back of a cruise ticket. If you do any kind of physical activity outside, like rock climbing or things like that, typically they'll have you sign a liability waiver. And what businesses now are considering is having customers and or the employees sign these, prior to entering the premises. I don't know if you've also heard, there's been a discussion among federal legislatures, where they've discussed putting in a law that would limit employer liability related to COVID-19. That's just been initial discussions. It hasn't gone anywhere yet, but I just wanted to point that out. So basically a liability waiver would help institute your business from liability for someone who gets sick within the workplace, okay? And so again, this is just kind of a general example just for informational purposes. However, liability waivers, the big thing about them, they're relatively new, especially related to COVID-19 and instances like this. You know, everyday normal activities that people do, sure, they're everywhere, but they haven't really been interpreted in the court system the way that they would be used, you know, by businesses and employers, you know, in the coming months or the next year or so. So typically in Georgia, and I'll get to this a little later, liability waivers are generally favored, okay? Georgia, if you didn't know, is an at-will state. You know, we're pretty employer and business friendly. So we haven't seen anything that would lead us to believe that any waiver here in Georgia would be disfavored or anything like that. But there are some things you want to know. If you're not here in Georgia, a lot of states, you know, they may have laws that, you know, disfavor these type of waivers. So it's just something to kind of put on your radar. So generally the things that court look at for liability waivers, there are a few things you want to have in it. Okay. So one, you want employees or customers to know what they're signing. You don't want it to be buried at the bottom of a document, you know, in the next to last page in, you know, 10-point font. You want it to be big, generally a separate document by itself, so it's conspicuous and obvious. Okay. You really want to reference negligence in the claims because that's what you would get sued for, right? It would be you didn't follow the standard of care that was set, you know, by the CDC or the level that the CDC recommended. I got sick because of your failure to do that and follow reasonable care, and you should have to pay me. So that's just one thing you'll want to put in there as well. Obviously, since we're in Georgia, you would want the choice of law to be Georgia. And generally for liability waivers, this isn't something you'd normally put in them, but just because of COVID and the pandemic, you'd really want to include measures that you've instituted and say, you know, I hold the company harmless for all, you know, liability rising out of X, and the company has taken these measures X, Y, and Z to make sure that, you know, the customer, the employee isn't harmed in any way. Okay. And I know I'm going a little fast, but like I said, I know we're rushed for time, so I want to get through everything. So if you have any questions, just save them. And our emails were included at the beginning of the presentation. So if you have any questions, you can email us as well. As I mentioned, there's a general presumption in Georgia that liability waivers are favored. So there are 4 exceptions generally where they're disfavored here in Georgia, and they're pretty extreme. So generally where the Georgia legislature has said that a liability waiver, you know, should be disfavored. And obviously here they haven't done that, or where the waiver is contrary to good morals and contrary to law. Obviously, since this is so new and the coronavirus is such a new situation, that's not the case either. Or the contract is entered into for the purpose of effecting a legal or moral agreement. Also not really applicable. The courts could interpret these situations, you know, a few different ways based on COVID-19, but we just wanted to draw your attention to that fact as well. Generally speaking, workers' compensation is an employee's exclusive remedy. So just for employees, not for customers. So if they get sick in the workplace, so usually that's the path they'll have to pursue. Again, we haven't seen anything to, you know, change that fact. But obviously, we'll keep you updated. If you shoot us an email, we can get you on our client mailing list to let you know if anything like that comes out. And again, just kind of as a last slide or next to last slide for liability waivers, don't try and draft these yourself. If they get challenged, you know, and you have to go to court over it, you really want to have an attorney look at it, and that way they're familiar with it and comfortable with the language that it says. That way, if it ever is challenged, you know, that attorney can get up and say, hey, you know, here's why I did this, you know, and help you fight it if it's challenged. Okay. So moving on to legal implications. So now this is kind of some of the juicy stuff that I mentioned earlier that we talked about. So there's a lot of legal issues that have popped up due to COVID-19, a lot of stuff that people aren't thinking about, and a lot of stuff maybe you didn't know. So we're going to kind of draw your attention. We're not going to get really in depth for those issues just because there's so many. But like I said, if you have any questions, you know, let us know after the fact, and I can help you out with any of those. Okay, so I'm sure if you haven't, sure you have, but if you haven't, the Family's First Coronavirus Response Act was passed back in March, I believe. Basically, it provides leave for employees in certain situations. The two main parts that relate to the leave are the Employee Paid Sick Leave Act, which provides 80 hours of paid sick leave for certain situations for employees. And there's also the extended FMLA portion, which provide paid FMLA leave related to child care only. Okay. So generally the FFCRA, the law is the floor, you can do more. When you provide leave under the FFCRA, it's reimbursable through a tax credit. The IRS website, you can Google it. It has information about what you need to keep as far as documentation, so you can claim those tax credits. FMLA, generally, there are different applications for it for the extended FMLA under the FFCRA. So just make a note of that. My point of mentioning that is generally some smaller employers may not be covered by FMLA, but you're almost absolutely covered by the FFCRA because it extends coverage to employers with less than 500 employees. The DOL guidance is updated constantly. They have a really helpful FAQ where questions are published almost daily. Initially back in March, they were publishing them and not letting anyone know. And as the situations rolled in and they got questions from attorneys and outside individuals, certainly they would update that as they could. But, take a look at that and Google it. If you have any questions after the webinar, after looking at the FAQ, let us know. I have to help. So the FFCRA went into effect at the beginning of April and expires at the end of the year. So essentially, if an employee, as of right now, if they haven't used their leave by the end of the year, then it'll just expire in December. As I mentioned, it applies to employers with fewer than 500 employees. You have the paid FMLA, the paid sick leave. There is a retaliation provision in there. It also provides job security for employees. As I mentioned, there's a tax process you have to go through to claim tax credits. There's a posting requirement, which I believe I will get to in like a slide or two. If you don't have that posted, you are required to, so be sure you get that from the Department of Labor website. And there's the poster that I mentioned. You can go to this link if you can click on it, or you can just Google FFCRA poster. That's certainly something you want to have up. And the box in the middle kind of explains the scenarios for what type of leave and when it has to be provided. All right, so this is just the situations for the paid sick leave. As I mentioned, it's 80 hours. And basically based on the situation, essentially what the employee is taking leave for, it'll vary the rate that they're paid at. So generally speaking, when they're taking leave for their own accord, it's their full pay. When they're taking leave for someone else, like if a family member has COVID-19, they get 2/3 the rate of pay. There are daily caps on that. And like I mentioned, this will not carry over as of right now into 2021. These are the qualifying events. I won't go over them. They're pretty clear cut. These situations can be, difficult based on, if you tweak one or two factors. If you have a really specific question, just let us know and we'll help you out the best we can. Again, paid expended FMLA, that's part of the FFCRA as well. Just wanted to point that out. It's only at 2/3 pay and it only relates to child care. So an employee has to be taking leave to care for their child, if a school or their daycare is closed. The employee has to provide a certification and the name of the employer or the daycare that's closed. We will send out a form. I'm not sure if Susan has provided them yet. Just a sample form you can use for your employees to request leave. Okay, I'm going to skip this one because I've summarized all this. Let's see. Okay, I'm gonna move on to wage and hour. It's just something to point out. In Georgia, it hasn't been that big of a deal yet, but it could be. Hazard pay, it's something that some employers offer. I just wanted to point it out to you. If you are offering hazard pay, be sure it's included in the regular rate under the Fair Labor Standards Act in calculating an employee's overtime. Some employers didn't know it had to be, so that's just something we like to point out. Temperature checks, if you didn't know, the EEOC has authorized temperature checks for employees, and actually they've authorized COVID-19 testing, which I'll get to in just a minute. But just be sure that you're paying employees for that time that they're being tested. Let's see. So I'll skip to the EEOC guidance. This is pretty helpful. They have a lot of information on their website about what employers can and can't do, about how much information they can request. Generally, the big thing, as I mentioned previously, that's come out of this is employers can take COVID tests, and they can also take an employee's temperature. We have a certification each day before we come into the office that we have to, certify that we haven't had a fever, been exposed to anyone like that. Just when you're collecting this information, be sure it's private and kept confidential. Let's see, I'll skip through these. I'll skip this one as well because that kind of goes to what Mel is going to talk to in just a few minutes. And
yep, the ADA issues you're going to cover.
I'll let you talk about those, or the NLRA, since they're kind of intertwined by protesting. Okay. I'm going to turn it over to Mel Hayes right now to talk about some safety concerns in the National Labor Relations Act.
Thank you, Graham. The old NLRB, the National Labor Relations Act, covers issues related to the workforce, particularly those dealing with strikes and employee protest. And so let's talk about that just for a few moments. An employee strike is the classic situation where an employee refuses to perform work. And there are certain types of strikes. What's called an economic strike is one where an employee strikes over working conditions, wages, and hours work. And an employee there can be replaced, and in fact can be permanently replaced by the employer of another employer. If an employee engages in what's called an unfair labor practice strike regarding unfair labor practice charges under the National Labor Relations Act, then they can't be permanently replaced, but only temporarily replaced. In other words, if they make an unconditional offer to return to work, they have to be put back at work. But a strike is where an individual has a complete refusal to do work. For the strike to be protected, as I just mentioned, it has to be a complete refusal to do work. It can't be a partial refusal. In other words, it can't be refusing to do certain jobs, or it can't be what's called intermittent, where they strike for a couple of hours and then come back to work and then go back and forth. An intermittent strike, where there's a pattern of doing that, is not protected. And so that carries over to this area where it's also a purely political strike. It's not protected unless it has a nexus or connection to the employment, to the workplace. And so those are things that come into play depending on the facts and these sort of situations. Now, what about strikes regarding safety? Well, a protest or strike over safety it is in fact an economic strike, and it's protected to the extent that they can be permanently replaced, but they cannot be fired. Likewise, there's a little known section of the National Labor Relations Act, Section 503, that provides special protection for a strike over abnormally dangerous working conditions. And in that situation, the person cannot be replaced. They cannot be fired over their strike over abnormally dangerous working conditions. Those are conditions that are objectively dangerous and expose a person to serious injury or death. And so there's a big difference in the nature of the strike. As if it's just subjective fears of safety, then it falls into classification of an economic strike. So it's the bottom line for an employer is it's important to know that when you get involved in a safety strike, it's not a basis when a person refuses to work. It's not a basis for discipline, and that's where employers get in trouble. The law distinguishes between permanently replacing somebody and disciplining them. So, Graham, I think that strikes in a nutshell here.
In a nutshell. Okay. Well, just since we've got a few minutes, I don't want to hold anyone else up. Did we have any questions? Let me see.
We do, Graham. I have one that I can ask that somebody asked early on, and it's actually a curiosity for us too, and maybe for some others on this call. If you're a business or an organization such as a chamber or a growth and development firm, or fill in the blanks, and you bring people together that aren't normally a part of your workforce,
okay,
what are the liability issues there? If you're talking about event-related stuff or meetings, if you're bringing people into your space, whether you're meeting on site or you're meeting at an off-site location under the guise of your business?
sure. So essentially, like a chamber meeting, like if you have a luncheon or something like that. I was just
going to say we have a lot of event related organizations who are part of our membership as well. So yeah.
I would say you would want to take a lot of the same measures as you would if you were an employer or you were operating a business. I think liability would be generally about the same, just as long as you're taking the same measures. If there's a governor order in place, which you always want to check out those just to see, social distancing is, required, masks, of course, hand washing, general things like that, you should be okay. But again, if you get into the issue of liability waivers, is kind of like a participant thing, like essentially like a business. Again, you have a lot of the same issues or, I guess, unknowns as you would if you were a business or, an employer. So I don't know that it makes that much of a difference. The bigger issue is that you're bringing, your employees generally, where they are for at least, 8 hours of the day. If you bring in people from, all over the county or wherever, you don't really have an idea of where everyone's been. So, it's a lot harder to make it, safer than you would a workplace. So I think it's a little bit harder in that scenario.
Okay. And in every example of that, do you recommend that participants sign off on a liability waiver?
I think it makes sense right now. And again, it's a struggle because they seem like a good idea, but it's really unclear how they'd be treated in the court system. So essentially, it's possible that, you could sign a waiver and then the courts hold them invalid. So, they're not really worth anything. Certainly, I think the waivers, assuming they're upheld, sure, they're great. But as long as you're doing all the other things as well, it'll be really hard for someone to say that you were negligent or anything like that. So I think, again, the bigger part is, maybe if you're having a meeting like that, have a certification that someone has to fill out or, sign or acknowledgement and says, hey, I haven't been around anyone with COVID. I haven't had a fever. I haven't traveled out of the country, things like that, will show down the road, like, look, we had no reason to think so-and-so was maybe a carrier or was asymptomatic or anything like that.
Sure, that makes sense. And I think, say that again, I'm sorry.
The checklist, and I think it's one of the materials I provided, that's very important. So go down the checklist and the certification. Those will go really far in showing that what the employer, the business was doing, was part of keeping everyone safe and healthy.
And maybe just to bounce back to what I was covering about strikes, you don't have to have a union to have a protected activity. It's called concerted protected activity, and that's when one employee acting on behalf of others or several employees engage in a protest. And so a lot of companies think that there has to be a union involved. It doesn't.
Okay. That makes sense. And then on the liability, I just did, for those who are looking for it, I just did upload the checklist to the chat function if you want to grab it right now. And regarding liability waivers, this is a question that has been asked here in the chat box, and I've received it on several occasions as well. As far as liability waivers are concerned, are they industry specific, or does one size fits all? So
this will be industry specific, just because, I mean, especially if you're an employer, I mean, what someone does at a plant or a factory, that's mass producing, some kind of textile or something is going to be a lot different than just an office worker, somewhere in Atlanta. So those definitely one size fits all. I think that's where businesses and employers certainly get in trouble with, hey, I'll pull this agreement off the internet and have so-and-so sign it. And, I'm just going to hope it sticks. I mean, certainly the resources that, we've kind of mentioned on this website. And again, always have an attorney read over something like that. I think it costs you a little money up front, but, if you go to court, you've been sued and you have this waiver and it's not held up because it's not written correctly, it's going to cost you a lot more in the long run.
Right.
So I just wanted to mention real quick, I know we're out of time. There's some resources here on these next few slides. The Contangy website actually has a coronavirus section, links to a lot of helpful things for employers and businesses as far as where to go if you have a question for industry specific things like the Department of Labor, OSHA, and the CDC and things like that. So certainly, if you have a question, come to us, go to these FAQs. Certainly there's a lot of help out there. So we appreciate you having us.
Thank you. Do we have any more questions, Candace?
Is there anybody out there that has anything else that they want to ask before we end our session today?
So I would ask Scott on behalf of his committee, which is the Resiliency Task Force, if there's anything top of mind you have specific to this from the work that group is doing. You got to unmute.
Sorry, guys. We had, just as a matter of example, we had a company, a bunch of employees walked off the job due to unsafe conditions. It's a non-union plant. And, so I think more and more you get people are very anxious nowadays. And, the concerns that we always have are, workers that either don't come in. We had another major employer here in Coweta County say what do they have, over 100 people called out sick, either with them or someone that they know. So they're I don't know anecdotally if they're taking advantage of situations or if it's all accurate, but it's hard to get staffing now to a certain extent.
That's why it's really important to communicate to employees that your company is doing everything humanly possible to make the workplace safe. And so we encourage clients to spend some time really communicating that and drilling down to the basics so that you try to alleviate those fears to the greatest degree possible.
If an employee refuses to come to work because they feel it's unsafe, in Georgia law, can they be terminated?
No, they can be permanently replaced, but they can't be terminated.
Okay.
And the distinction is when somebody's permanently replaced, they've in essence have to make an unconditional offer to return to, they have to end their strike and make an unconditional offer to return to work, and they can only return to work if there's a place available for which they're qualified.
Okay.
Well, that's great information. This is such a fluid topic that I know some of you are probably going to have questions that pop up at odd times. But again, Susan will be sending you this information. I know that Mel and Graham, your team is always available if anybody wants to follow up with you. There are these great resources you see on the screen, but also if you, the email that went out to everyone this morning has a whole lot of resources from the U.S. Chamber, and these are some of the best resources. Susan and I talk all the time about, they're probably the best resources we've seen anywhere. So I would encourage everybody to read them and follow them and use them. I know Scott talked in our meeting this morning, following the CDC guidelines is very important. So, all of these things are, crucial to our ability to be successful. If you do have questions, you can either reach out to Susan or myself or directly to Mel and Graham. And also in the next few weeks, so we're working on some more programs, one of which is going to be a Piedmont delivered program, specifically to the things they recommend on the recovery side. So we'll be sending you dates and information. If you have any topics that you are interested in or that you would like to see us try to find subject matter experts, just reach out again to myself or Susan, and we will absolutely build that into the schedule over the next few weeks and months. Or any ideas you have, this is all about, we're all, you hear it all the time, we're all in this together, and we are, but we need to help each other, we need to support one another. So please do that. And again, just Mel and Graham, thank you so much for sharing this afternoon. I know that we probably should have given you a little more time because you had so much to review. Maybe we'll have you back if you'll come back. And I see Dr. McKay shaking her head. Tina, would you like to have them come back? I know. So perhaps we can do that. That would be lovely. But thank you so very much. And for all of you that have joined with us today, thank you for joining with us. And if anybody is still interested in serving on one of our committees as a part of the recovery task force, please let us know and we'll hook you up. And I guess that's it. Susan, did you have anything else to say?
No, the only thing I'd like to add is that next week's webinar featuring Glenn Shepard is being rescheduled. So if that's something that you were interested in, it is going to be put back on the calendar after the holiday. So it will probably be on the docket for August, but that's going to be tremendously informative for our employers and our managers. Other than that, Graham and Mel, thank you so very much for joining us today. Again, apologies for those glitches, and we hope that you will consider joining us in the future because this is changing so rapidly and you are tremendously knowledgeable.
Thank you.
Thank you.
Thanks, everybody.
Thank you.
Bye-bye.
Bye.
Mhm.